Okay, thanks for the organizers' nice words. It's really a wonderful opportunity for me to share with all guests here some progress in Chinese pharmaceutical IP system. Well, I guess it makes sense for someone like us who actually practice Chinese law to give some insights about this system and also share you some of our real case questions, progress, and comments. Anyway, so let me put it this way. So the title I'm actually trying to introduce is the implementation of patent linkage system in China, and also some case studies. Yeah. Well, my topic would be comprise these four components. I would actually give a sort of high-level introduction for these four parts. The first one is the introduction of a patent linkage system and the background. And then the second, I have to take some time to just give you, again, an overview of what is the current patent linkage system in China. We call it version 1 patent linkage system in China. Then I will give you a very brief introduction of the first patent linkage case in China, pretty much just a very high level introduction for that. Then number 4, I would just give you some examples of the typical problems we have encountered when we actually trying to utilize this patent linkage system and what we hope the system can be improved. Let me put it this way. So that's the 4 part I'm going to introduce. So this one is just the background of why China actually introduced its patent linkage system. So start from these slides. I'm going to actually, because the contents, so I'm going to pretty much put the English version first, then later on I will show you a Chinese version. So bear with me for audience who can only see Chinese. You may have to wait just a slight 1 minute or 1 second. This is just for the background. Now, why China need a patent linkage system? And let me put it this way: we have internal desires. We also have outside pressures. So internal desire is because China has adopted this so-called border exemption since 2008 in the last patent law amendments. There, Chinese law specifies any actions, including producing, using, or importing patented medicine or patented medical device for the purpose of providing the information as required for administrative review and approval, and producing, importing the patented medicine or patented medical device exclusively for that purpose are not infringement activity. So in this way, it's actually open the door for a generic drug company to apply their generic drug application, where the patent holders, before the generic drug is approved, has no way to stop the generic company. So that actually is kind of like a unilateral introduced the border exemption, which actually serious damage the balance between the innovative drugs and the generic drug in the industry. We know in the past 10 years, actually, particularly in the past 5 years, the biomedicine industry booming in China. So there are lots of more and more Chinese company has their own innovative drugs. They are having the desire to create a more balanced system. So that's the way I'm saying we have an internal desire to create a patent linkage system in China. Then the outside pressure, as you all know, is China-US also entered into a trade agreement in 2020, January 15. There, China also promised it's going to establish a mechanism for early resolution of patent dispute in the pharmaceutical industry. And that discussion was all about why the innovative drug company face the challenge in China pharmaceutical market because of this particular unilaterally introduced BOLA exemption. So that's from outside, from inside, we have such a desire. Okay, so here is so China with such desire to create a patent linkage system. So in this new amendment, which was released in 2020 and took effect in 2021, they create a patent linkage system with so-called Chinese characteristics. So just some highlights I want to mention here. First of all, in this Chinese patent linkage system, a generic company would now be considered as infringing the patent. The only action the patent holder can take is to ask the court or the Chinese Patent Office to confirm whether the drug, the generic drug, fall within the protection scope of the patents. And if the answer is yes, then according to this legislative structure, the Chinese FDA, the NMPA, would stop the approval process of this generic drug application. So that's the way, by doing so, China creates its own patent linkage system. In order to take advantage of this system, the patentee can take two approaches. First, they can go to the judicial approach, and the second, they could also take an approach we call the administrative approach. That administrative approach is they need to bring this case before the Chinese Patent Office. So later I will explain this. You see the actually third paragraph. In the patent law, it specifies the law would require these two agencies, the Chinese FDA and NMPA, and the Chinese Patent Office, to fill in all the details. And this is a very interesting thing you can always see in Chinese legislative works. It's actually legislative skills used quite often by Chinese legislation. The law is only specify a very high-level framework. All the details will be filled in by this government agency. This is the development of this patent linkage system. And if you see, this is just a timeline. I think it makes sense for us to highlight the timeline for here. You see here, before the patent law, the final patent law was released, the Patent Office and the Chinese FDA, the NMPA, together already draft a so-called implementing measures for the early resolution mechanism for drug patent disputes. This was in September 11, 2020. And after one month, then the law finally released, which is specifies such a mechanism. And after this law created such a system, then both the Chinese Patent Office and the Chinese court system release their own draft regulations of how to handle in this case. And then you see in till the day of July 5th of 2021, then both the court system and the Chinese Patent Office and also the Chinese FDA, the NMPA, finalize their regulations on this patent linkage system. And all these three together, we call this the version 1 of Chinese patent linkage system. Okay, here is just some highlights of this Chinese patent linkage system. Remember, you need to first register your patent. If you compare with US patent linkage system, there they have an original book, orange book. Here in China, they create such a patent registration information platform. So you have to register your patents. And the MAH has to do this within 30 days after you got the drug approval. Then after you list your patent, the generic drug company, when they submit their generic drug application, they have to also make a statement about all these patents listed on this patent information list. You have 4 types of statement. We will cover that. Then the patentee could launch an action under this patent linkage system, this provision, either, as I mentioned, either before the court or before the patent office. And that action is only to confirm whether the drug falls within the protection scope of the patent. So it's actually, in fact, this is not an infringement action. This is kind of like a declaratory judgment action. Okay, so this slide just highlights what type of patents you can list in Chinese registration information platforms. Compared with US, pretty much the same. You can list the drug patent that covers the active ingredients, that covers formulation or composition, and also the method of use. However, for these active ingredient patents, remember the polymorph patent cannot be listed in China. As comparison, in US, you can list this polymorph patent in US. So if you have a polymorph patent in China, unfortunately, you cannot take advantage of this patent by filing a patent linkage action. Here is the 4 category patent statement or patent declaration. It's pretty much the same as the US system. So if you are familiar with the US system, then you know which category refers to what. It's only slightly different is in the category 4 statement. Here in China, they divide this into 2 subcategories. The 4.1 is refer to the patent should be invalidated. The 4.2 refer to the situation where the generic drug applicant believe their drug does not fall within the protection scope. Okay, this figure looks a little bit complicated. Bear with me one minute. Let me just lead you to read these figures. This is a summary of what has been established as for this patent linkage system in China. And if you follow the green background on the left side of this slide, you see the MAH, a drug owner, after obtaining drug approval, they need list the patent on this so-called patent registration platform. So after the MAH lists the patent on this patent registration platform, then the generic drug company, when they file a generic drug application, they need also file or issue a patent declaration against this patent listed in this patent registration platform. And among the 4 types of patent statement or patent declaration, only the number 4, category 4 statement would allow the patentee to take further action. So here is just in the middle, this square shape, green background. Here, if the generic drug company issue the category 4 statement, then the patentee can launch action. That action can go either to the court or to the patent office. And after you launch this patent linkage action, the Chinese FDA, the NMPA, would make a 9-month stay for this generic drug application approval process. The technical review process will go on, but the approval will be stayed for 9 months. If within these 9 months you have a result, if that result is actually the drug fall within the protection scope of the patent, then the NMDA will stop the review process, wait until the patent expires. If any ruling from the court or from the Chinese Patent Office saying either the patent is not valid or the drug does not fall within the protection scope of the patent, then the review and the approval process in the Chinese FDA, the NMPA, will be resumed, and the drug will be finally approved and go to market. So here, just let me draw your attention to this yellow box in the bottom. There, Chinese Patent Linkage System also allows the generic drug company who make the first successful challenge to the drug patent to enjoy a 12-month exclusivity of the market. The only problem is all the details hasn't been figured out. So here, I just will not dwell in this part to give you more details, since even we don't know the details so far. We are still waiting for the more specific rules and regulation come out. Okay, here I'm just going to give you a very high-level overview of the first case of this patent linkage system. Next, this is what you see here is the time when the first patent linkage action case the judgment was issued. You see in the middle, the three judge comprised as a panel, and there the judge actually made the judgment right on the spot, which is very rare in China. Anyway, this is just give you an impression how the Chinese court system looks like. And this case is about two parties. One party is a Japanese pharmaceutical company, the patentee, and the generic drug company is a local company, and that patent is a patent relates to a formulation. Here, this is just the details of the patents, so I won't spend time to explain the detail of these patents. Next. Anyway, so the court, after review the case, believe that the drug does not fall within the protection scope of the patent. So then actually made the judgment saying the drug does not fall within the protection scope. And this case, as we understand, is now under the appeal process. This is the first case where the Chinese court issued in this type of patent linkage case. As I said, also the patentee can take a different approach to ask the Chinese Patent Office to make an adjudication about whether the drug fall within the protection scope of the patents. So this one is okay. So this actually just one side note about this first case from the court. Here, the concerned patent was actually invalidated, so totally invalidated. And normally, according to Chinese law, if a patent is invalidated, then the court will immediately dismiss the whole infringement action if there is action on this patent. But for this new type of patent linkage action, the court did not dismiss the case. Even after the patent was invalidated, of course, that invalidation decision was in appeal. The court still issued a judgment saying, regardless the patent is invalidated or not, we believe this drug does not fall within the protection scope of this patent. So the generic drug application can be continued reviewed. So that's what happens in this case. Now, this slide is just showing you another first case, but not from the court, but from the Chinese Patent Office. We call the administrative approach. Here, also the Chinese Patent Office issued a decision on a case where the Chinese Patent Office also believe that case the patentee's patent does not cover the generic drug company's drug. So that generic drug application should also be continued reviewed. So that was the case first issued by the Chinese Patent Office. So it's interesting to see both the Chinese court and the Chinese Patent Office picked up a case where they believe the generic drug does not fall within the protection scope of a patent. And we don't know whether there is any coordination between these two institutions. But somehow we, or at least I personally believe, that actually gave you a sign. The Chinese government are still not fully ready to be showing to support the patentee of the pharmaceutical patents. That was the background because previously the majority of Chinese local pharmaceutical company are generic company. So the internal policies to encourage the domestic industry. But as I said, in the past 5 years, the local industry has shown more and more innovative strengths. They are making themselves innovative drug companies as well. So the whole atmosphere here also changed. There are more policy, more laws to encourage the protection, to protect the patent holders' rights. But in this case, particularly in this first case, where the court and the patent office also both choose the case where they believe a generic drug company does not fall within the protection scope, shows a very interesting signal. The government is still trying to balance itself on which side they should take more steps. Anyway. So this fourth part, just let me give you a very brief introduction of this fourth part. This is a case we are working on for Amgen regarding tablets Amgen has. Amgen actually marketed this drug in China. The MA was approved in August 16th, 2021. And this drug has 2 patents listed in the so-called patent registration platform. This is the timeline for the relevant events. Let me just explain this. You see, in 2021, August 16, the drug was approved for China market. And as I said, within 30 days, the MAH has the obligation to list the patent on the registration information platform. So here, 2021, September 13, the MAH lists the 2 patents on this platform. Now, however, just 3 days before that, the generic drug company filed a generic drug application and also made a Category 1 patent declaration because that time the MAH has not listed the patent on the patent platform. So the generic drug company made a Category 1 statement that is also correct, and the Category 1 statement is mentioned there's no patent on the registration platform. Here is just repeat what I said. Both parties actually fulfill their duty under this version 1 patent linkage system. The MAH listed their patents within 30 days. So in a timely manner, they listed their patents on the registration platform. The generic drug company also fulfilled their duty. They checked the patent registration platform. They haven't found any patent that time, so they made a Category 1 statement. However, according to the current patent linkage system, it's the patentee, as I said, the patentee can only challenge the generic drug company when the generic drug company made a category 4 statement. And so when the generic drug company made a category 1 statement, according current regulation, the patentee has no base to challenge it. So the patentee loses the right to sue, even with this patent linkage system established. And also for the generic drug applicants, they also face some uncertainties because the generic drug applicants is required to make sure the statement is accurate and authentic. And here, the generic drug company, after they file an application, they realize the patent were listed on the platform, so they should make a different statement. But they right now they actually are stuck in this process. They were told they have no way to change their patent statement. So here is the situation where the patentee stands. The patentee realizes there is a generic drug application going on, but because there is no such category 4 statement, they cannot file any actions. Even the patent linkage system is established, as we all believe. And also for the generic drug applicants, and they also face problems because they realize their patent statement is not accurate. But so far, they were told they cannot change their patent statement. So right now, what we are doing, we're actually trying to persuade either the patent office or the court to take a broad interpretation of this Article 7 of these implementation measures, to saying not only when there is a category 4 statement issued, then the patentee can file an action. It's also when there should be a category 4 statement issued, but there's no such category 4 statement issued, the patentee can also make commence an action. And we're trying to persuade the court or the patent office to accept this interpretation, and that's the work we're still working. So anyway, so the take-home message is this system is nice. We have such a patent linkage system finally established in China, but this is a very new system in China. There are lots of places need to be improved, and a lot of work need to be done. So that will be all for my next. Just give me 1 minute. I will give you a very brief introduction of myself and also my firm. So I, as introduced by the organizers, I practice in both US and China. I focus in pharmaceutical patent field. I practiced in China for 10 years and worked on both prosecution side and the litigation side. So the firm, Li Fang firm, is as the organizer introduced, is one of the best IP boutique firm in China. We focus on IP protection, both from the prosecution side and the litigation side. Of course, in addition to the IP work, we also provide service in antitrust, dispute resolution, and other fields of legal service. So we are recognized by many ranking systems. I guess that I can just give you some assurance. If you want, find someone in China to help to serve your IP needs. Okay, that should be all. Thank you.